سبيل الدموع سبيل مريح تنهدى يا صاحي كي تستريح وبث الدعاء الخفي الصريح يسعك الفضاء الرحيب الفسيح سبيل الدموع
Assalamu alaikum wa rahmatullahi wa barakatuh, and welcome to part 2 of the episodes that we're looking at the Usul al-Fiqh according to the traditional model. And the traditional model we're referring to, or the one that we're using here, is the Hanafi madhab itself. This fits in our series, Muslims in non-Muslim lands, in which what we're now sort of getting out to the listeners and viewers is the methodology which exists for the traditional model, in which the approach it takes, the hermeneutical approach it takes, to be able to analyze the text and be able to give a response irrespective of time, era, irrespective of situation one finds oneself in. And this is all in the context of whether a new model is required. And part 1, I hope you've recovered from part 1. Part 1 was very heavy. There's really no way of watering it down, even though, to be honest, I watered it down to as dilute I could possibly make it and still leave a taste of the reality behind. I didn't go into much detail. As I said, it was just a very I wasn't even scratching the surface, to be honest. Well, maybe we touched the surface, very little scratching that went on. And but it was mainly to give an idea, really, just to show the depth of the model that we have, to argue its case that it can't be considered to be defunct, it can't be considered to be no longer valid if all its intricacies, its detail, its depth is not investigated. The next part, or part 2 now, of Usul al-Fiqh will hopefully be less demanding on the mind, less challenging, but having said that, it's not going to be easy. So again, I appreciate if you could just sort of hang in there with me and get an idea for what we're going to discuss today. For those of you who do have some understanding of Usul, so those of you who had opportunity to study the traditional sciences, hopefully it won't be too difficult for you to pick up on the key points. Again, I stress the fact that if you have the text itself, it makes it a lot easier. You can go at your own time. You can even study this particular part as a text, so it gives you an understanding. I'm not saying that you then become in a position to be able to really understand Usul al-Fiqh in its great detail, and secondly, to then be able to apply it, far from it. But I hope it's also giving you an appreciation for the level of study scholars have to do, and the length of time and the depth and the variety of sciences which they have to become at least competent in, if not experts in order to be able to really apply it. And that, I guess, touches upon another point, which is the fact that there is an expertise required, and it's this expertise which is lacking, which leads in the majority of cases for individuals to do taqlid or be muqallid, yani accept the position, accept the authority of the school, because the expertise required at that level is no longer amongst us. To have that level of understanding is a mountain too high. So I hope that you've appreciated that a little bit better, to understand why that concept exists. But anyway, let's dig into today's episode. And today's episode, I wanted to touch upon that, which was the mujtahid. And till this time, we've been talking in particular about the mujtahid mutlaq, as it's referred to, one who is an absolute mujtahid, who writes his own usul and also then is able to derive directly from the sources. Those individuals are the ones which are considered as the fathers of the madhahib, and also their students. And then we have different levels, those who do tarjih, those who do tashih, and various other levels of ijtihad which exist, but there's still levels of ijtihad. We discussed, not in great detail, but we did discuss about the view that ijtihad as a science, as a practical application, still exists to this day. not to the level of kind of rewriting the script, rewriting usul, rewriting the fundamentals and the foundation of religious practice and religious behavior, but because of new situations. Sometimes in the books it's referred to as an-nawazil, and even after that the books of fatawa, is we see situations changing, circumstances changing. And also what we see is lots of development taking place, whether those developments are of a social nature, medicinal, political, and things of that ilk, where these changes are happening. And because they never existed, or exactly that type didn't exist whilst the books of fiqh were being written, it's very difficult to just kind of dip into the madhab and find a quote or find something in which this practice has already been discussed, look in a few sources gathered together and be able to apply that and practice that. So here what we're going to speak about is the mujtahid we're talking about is the one is applying sort of in the daily affairs when these new events take place. So that kind of mujtahid exists. But we're going to return back to, as you probably know, that we've been covering the usul according to Imam Shashi, alayhi rahmah. So in this case we're going to return back to that. And it mentions in the text, and I'm not, this is, even though there is a closer translation that you'll find in the book, I'm paraphrasing because we don't have the time to cover this. And the reason why I'm not going into depth is because the purpose of the series of these lectures wasn't to go into depth both in terms of the madhab and go into depth both in terms of the traditional approach itself in terms of its usul and its application. It was more just to give an understanding and then look at the broader application of it in the surroundings we find ourselves in, which is the minority status. So this mujtahid is trying to find a hukm al-haditha, yani a hukm, a ruling with respect to an incident which has occurred. So his practice will be to go to the book of Allah subhanahu wa ta'ala, then to go to the sunnah, and then obviously once he's applied that, in the case where ijma is not existent either, then he will obviously apply himself and he will try to reach an answer. And this is again referring to the al-mujtahid mutlaq, the one who has direct access to the sources. If you're talking about ijtihad in the everyday sort of contemporary ulama now here, and this is not again for any alim, this is for those mashallah who dedicate themselves in this work of research and are looking at fresh understandings and applying themselves. And when we mean by fresh understandings, to explain that, is that when situations change and when the context changes, it's about being able to find that answer, that response within the body of the text. So let's have a look at that. So first is to go to the sources, and then it mentions what about if contradictions or apparent contradictions occur between two verses of the Quran, say, then what will he incline towards then? And then the inclination is towards the Sunnah. And what if there is an apparent difference between the Sunnah? Then he will go towards the statement of the Sahaba and obviously correct Qiyas. But what if application of Qiyas is also contradictory? Then the Mujtahid himself will yataharra. He will apply himself, he will strive, he will contemplate, he will try to reach a decision based on his application of his knowledge. So this is obviously referring to in those circumstances where the mujtahid has direct access to the sources. In other cases, what he will be doing is, obviously in the madhahib, is following the text which exists. So istihsan. Okay, istihsan is looking at reasoning. So reasoning, and this is reasoning is slightly different than qiyas. This reasoning, what is referred to, is looking at sort of what's more fitting, more fairness, the sort of spirit of the law rather than the letter of the law. And these sorts of explanations have been given. We see istihsan explained in Nur al-Anwar. For instance, it mentions that istihsan is evidence which opposes the manifest qiyas. And he says istihsan can occur in athar, referring to khabar here, ijma, consensus, darura, and what's termed as subtle qiyas. Subtle qiyas meaning it's not apparent when you apply syllogisms or syllogistic reasoning or syllogistic logic. It becomes more apparent when you reflect a little bit more over what is actually happening and then apply some reasoning. And we have a number of explanations like salam, in which the product is transferred from the seller to the buyer with a deferred payment, it mentions. And this is an example of istihsan. So what's happening here rather is the product is transferred later and the payment is made earlier. And the reason being is that this is sometimes referred to as a bay al-ma'dum. Bay al-ma'dum meaning that the product doesn't actually exist at the time the sale is made. So salam here is referring to that buyer pays the seller and buys a product which doesn't exist. Now, according to the principles of buyu, that's an invalid transaction. Why? Because the product doesn't exist. You can't purchase something which doesn't exist. But due to athar, due to narrations, that has been permitted. And the reason why it's been permitted is because of the need of the people. But this was a saying from the Prophet ﷺ that both Bukhari and Muslim has recorded. We also have another type, which is istisna, which is requiring the manufacturing of khufs or things of that nature. So you can see that istihsan has been applied here, and arguably it's come through narrations. We see other things as well, purifying of utensils, for instance. Now, purifying of utensils, what should really happen is that they should be washed and rinsed like any other material when any najasat falls upon it in order to purify it. But it's not possible to squeeze knives. It's not possible to squeeze plates. It's not possible to squeeze cups. So how do you go about now purifying it? Well, what is purified is because out of necessity, i.e. it's impossible to rinse or squeeze out water from a knife, which is what should be happening, is the item, let's say a piece of cloth, absorbs water and then that water is rinsed out. And this is done a few times in order to make sure the cloth is clean. The other point that we have is the purity of the water which is left over from birds of prey. Now, Qiyas would suggest that because these are birds of prey, they're eating animals, whether it's rabbits or moles or small birds, then there will be blood on their beaks. And when they place their beaks in the water, in the drinking water, then like the cat, like the wild animals, like the lion, the bear, whatever, then the blood from its mouth will also reach the water. And as a result, the water will become impure. But because that's qiyas, but then again, this would bring difficulty upon people. However, if we think about it a little bit in more detail, we can see that actually the part of the body which the bird consumes the water from is the beak. And the beak, like a bone, is considered pure. It's not considered impure. Whereas the way a cat drinks, say, or a cheetah or a leopard or a dog, is that it takes the water through its mouth, which is flesh. And the saliva within the flesh is given the same ruling as the ruling of the meat of the animal. So as a result, it becomes impure, whereas in this case, it doesn't become impure. But in all cases, what we're trying to seek, if you look at the sort of underlying principle, the underlying principle is not to make things unnecessarily difficult. Otherwise, we could have accepted qiyas and the matter would have been solved. But it's trying to find if there is any possibility, legally, of not bringing any unnecessary difficulty upon people. And that's mentioned in Nur al-Anwar in particular. We also see in places where this effect, as it's determined, and I've mentioned already, is stronger. So in this last example that I gave you, a person would argue that it's not actually seeking ease with respect to the bird consuming from the water, but it's actually the reality. It's just that we've analogized upon the wrong thing here. We should have been looking at, rather than the animal of prey and the animal of prey, we should have been looking at area of consumption or use of what for consumption. Because all we've done is we've done qiyas upon the animal of prey. The bird is an animal of prey, the animal is an animal of prey, and the animal is, its leftover water is impermissible, so as a result the bird's leftover water is also impermissible. But what we should have been applying a syllogistic analogy upon, is to look at and say, well, hold on a second here, what body part does the animal use for taking up water? Well, it uses its mouth. Okay, what's in the mouth? What's the cause of the problem? Well, it's the saliva within the mouth. And what's the issue with the saliva? Well, the saliva is impure. Right, okay, that's fine. What body part is the bird of prey using? It's using its beak, which is like the bone or the claw or anything else for that matter, which is considered as pure because it has no blood flowing through it. So as a result, what we should have been applying analogy on is that is the item of consumption or the use of body part for consumption. That is what should have been looked at, not the fact of is it an animal which consumes other animals. So one could argue that this is not just seeking ease for the people, or it's not just trying to find a way out, a legal way out, but in reality it's what's the correct answer. So this is also has been discussed in places. So istihsan is an area which has been applied looking at the taking, and if we were to look at applying this, is looking at those issues, particularly when it comes to not acts of worship or not ritual matters or ritual practices, but really referring now to practices to do with transactions and business and things of that nature. So for instance, what we have here is if obviously the aim is within the Hanafi madhab in particular is to apply the Zahir riwayah. That's what should be done. But at the same time now, what is also needs to be taken into consideration is obviously the urf or ada, or the ada rather, the qara'in and ahwal, the sort of context that's around there, darura, and things of that nature. So it seems that there is more scope in application of the madhab depending on where that madhab is being applied. And we will see later in some of the other parts, depending on which country that's being applied, and we see differences. So in certain countries, the Sharia is not applied. And in certain countries, the Sharia is applied. So we can see that the context has proven not only to make minor modifications to the Sharia, but actually to its full application. So next we look at is urf, okay, social customs. And these are customs, and we've seen that urf itself has been incorporated within Islamic law. In certain places it's referred to as an asl, it's a principle, because we see that many source texts as well, or rather than say many, but a large number of source texts, also we find that the ruling is actually based on the urf. So even though we find it in the source text, we see that that ruling is based upon an urfi practice. And if that urfi practice is changed, then likewise we see a change in that ruling as well. And that's also if obviously we've seen, and if you look at the Sharh Uqud Rasm al-Mufti, we find a small sentence or so in which he says, or in his poem we find, al-urfi shar'i lahu i'tibar ladha alayhi al-hukmu qad yudar. And it means custom in law or practice or whatever you want to call it is considered, and so upon it ruling can be established. And I'll take the explanation he gives, because in his Sharh, in his commentary of it, he says that referring to Imam Ghazali, says in Al-Mustasfa that urfan ada are those things which exist in the hearts, brought about by the intellect, and which is good, natural disposition is accepted. So that which is of a good, so we're not looking at the urf of people which we wouldn't normally consider to be of a natural disposition, something which is away from. So we're talking about, so there is already a value, if I can use that word, that we're adding to the urf and the ada. It's not just urf ada blanket, it is urf ada which is that occurs to good natural disposition. In Sharh Tahrir, ada is that matter which occurs repetitively without any intellectual or intelligent input. It's something that we do naturally, it's by habit. And that's why it's called ada, because ada is habit. In Ashbah wa Nazair, the sixth legal maxim that's mentioned is habit is taken into consideration in passing judgment, yani ada muhkama. Its origin is in the statement that the Prophet ﷺ said, that which the Muslims consider to be good, then it is good itself. However, this is actually a statement of Abdullah ibn Masud radiallahu anhu, rather than being a narration and a statement of the Prophet sallallahu alaihi wasallam. However, principally it's still accepted. So we can see here that there is this taking into consideration natural good disposition, character of a person, or of a group of people rather, of a society in fact, that is taken into consideration, and the natural habits of them is also taken into consideration. But the disclaimer is there, is underpinned by the view that it is good natural disposition. Now, how you define these things is open to debate. However, the way it's defined within the Hanafi madhab is, and I guess with all the madhahib, is that this is what would be considered, normal, what good people do, basically. Good habits. So we find things like honesty, fairness, looking after guests, things which all societies, irrespective of religion, irrespective of culture, will take into consideration. But again, there'll be different ways, say, of expressing that culture. So maybe in the UK, sticking a thumb up to somebody to say, thanks, is acceptable. But maybe doing that somewhere else in another society might be seen as disrespectful. So you've got to take on board the culture of the people and how they consider those particular types of acts. So you can see here, this is a madhab which is dynamic. It's not a madhab which is sort of, as it's viewed, sort of fossilized and out of touch and resistant to change and whatever. It's not, or doesn't take into consideration change, rather. That would be more correct to say. It's clearly taking into consideration the environment it finds itself in terms of practice. There's obviously a number of other things that I could discuss. In fact, this point I will do. It's mentioned again in Sharh Rasm al-Mufti, Sharh Uqud Rasm al-Mufti, that in Biri's commentary of al-Mabsud, it's mentioned that which is established by urf is like what is established by text, nas. It says that, know this, that many of the rulings of the Mujtahid Sahib al-Madhab, yani Imam Abu Hanifa, were based on that which was in his urf and in his era, so they will have changed with the changing of the era due to, and he mentions a couple of things, fasad ahli dhaman, or due to umum al-darura. Now, fasad ahli dhaman means that the people naturally are becoming more corrupt, and we've seen that. Whereas taking a witness statement 1,000 years ago would have more veracity and accuracy and truthfulness in it than if we were to take a statement now. We can see even just within our own lifetimes how people practices have changed. Certain things which were taboos and people would never dream of doing are now seen as people turn a blind eye to it without thinking anything of it. So what's happening is the societies are changing, and society becoming more and more irreligious, or becoming less religious, or even abandoning religion altogether, is bringing a different type of corruption within society. People will disagree. They will say, no, we disagree. Religion actually it's religion which brings about great death and murder and things of that nature. But that's not necessarily true, because what we're talking about is on a social level within society. Common decency, abusive language. People would be sort of, we don't have to go too far back to see what society really was like to where it is now, and what people are facing, both in terms of attacks, abuse, wanton damage, things of a nature which is unprecedented, and it just seems to be sort of going in one direction. We see further discussion of this again in another point, which I think I'll quote in full, which is very interesting. And it mentions, Imam Ibn Abidin alayhi rahmah mentions that, with respect to all these issues whose rulings change due to the changing times, either because of darura, or urf, or qara'in al-ahwal. So he mentions three things. One is darura, which is necessity, the situation changes, or urf, which is the custom or the culture of the people, or qara'in al-ahwal, which is the context or the circumstances. It means these rulings are not outside the madhab. Because if the Sahib al-Madhab lived in this era, he would also say the same, and had this change occurred in his time, then he would not object to it. This is what has encouraged the Mujtahidun fil Madhab, meaning the people of correct opinion, from the latter scholars in going against the texts from the Sahib al-Madhab in the books of Zahiri Riwayah, as these were established on the basis of what occurred in his era. Very interesting point. It's quite remarkable that giving rulings against the Zahir al-Madhab is actually going according to the madhab. It's not going against the madhab. Why? What he's saying here is that the principles of the madhab need to be practiced. That's the key point here. But remember, we're not talking here about ritual acts or things of that nature. What we're talking about is social practices. And again, it's those which are not mansus alayh, as we've already discussed in other places. So that's a very interesting point. And this is building up to how Muslims find themselves in a minority context and how those things play a part in terms of what they can and can't do, or rather, what they should and shouldn't do. And that's what we're going to talk about. So this is sort of explained in great detail again in the text, but I'm not gonna go into it too much. What I will do is obviously move on to the next part. I'm keeping this relatively short compared to part one, and what we're going to look at now is the darura. And darura, what we're talking about here, is the Sharia compliant necessities. So when we're talking about necessities, okay, we're talking about those things which makes life difficult, if not could potentially bring about death to a person. It could potentially harm the person. So let's take an example. A Muslim is not permitted to eat pork. It's impermissible for him and her. But if it was at the point of starvation, if it was at the point where their body would get destroyed, then in those particular situations they are permitted to consume pork. Let me rephrase that. Not only are they permitted, they are required to eat that in order to save their life. So here we can see where something which was impermissible, clearly mentioned in the source text, the situation has changed, the context has changed until now this person is a normal person, he's alive, everything is fine, so it's impermissible for him to eat pork. The situation changed where now he's literally on death's door. Now it's permissible for him to consume it, rather not permissible, but compulsory for him to consume it. So we can see how the condition has changed, the context has changed, which has pushed him towards consuming that piece of meat. But again, this is also mentioned too within the Quran itself, a source text, a text mentioning the permissibility of it. Another example is destroying other people's goods. Damage other people's property. Under no condition really in the everyday and age can a person destroy another person's property. However, if somebody's on a boat and the boat is about to sink and there's no way that it's going to stay up because of the weight of the people and the luggage on board, now it's permissible to throw somebody else's luggage out into the sea in order for the boat not to sink and the people survive. So again, context has changed, something which is quite clear not permissible to do. And these are what's termed as daruriyat. And these are usually misapplied or misunderstood. And what we start to see is that everything suddenly becomes a daruriya. And what happens is that it's split into sort of three areas. We have daruriyat, we have hajiyat, and we have tahsiniyat. So daruriyat is the absolute essentials, which are 5 in number: preservation and safeguarding of religion, life, progeny, property and intellect. And we have hajiyat, which is complementary, and then we have tahsiniyat, which is improvements, perfecting, things of that nature. If I give an example where you can see all 3 of them in action, that would be easy to then picture in your mind. Let's take clothing as an example, and I will look at the 3 types: darura, haja, and tahsin. So in terms of darura, what is darura? Well, if a person covers their body with cheap ordinary material, then it will be sufficient for an individual, and this is darura. So as long as they can cover their body, cheap ordinary material, that's done. They've met their needs. If, however, the individual chooses to wear clothes according to the climate and season, as otherwise the individual will go through unnecessary difficulty, feeling cold in winter, feeling too warm, hardship, then this is haja. And finally, if by wearing beautiful clothes of quality, which are legally permissible, he appears well dressed, then this is tahsin. So you can see the 3 gradings. Okay, and in the text I've drawn examples with both food and shelter. There's one other topic which is hiyal or makharij, legal devices or stratagems which exist, and I'm not going to go into too much detail there. but you can see that within the text as well. And then again, I've touched upon the terminology of the different gradation of rules which exist, which we had, if you recall, even within Usul Shashi discussed them. So we're now coming to the end of this part, which is looking at the second part 2 of the Usul al-Fiqh, the legal theory according to the Hanafi school of law, before we move on to the next part, which we'll look at, or I will introduce at the end. And it just leaves me now to introduce what's referred to as the Qawaid al-Fiqhiyya. And the Qawaid al-Fiqhiyya are legal maxims of fiqh. Okay? And what these basically are, in a way, is the distillation. And if you recall, going back a few episodes, I'm struggling to recall with the various series that I'm recording where it was, but if you go back a couple of episodes, you'll find that I discussed taking a certain chapter or taking a certain topic and then bringing it all together and distilling out a legal maxim, and that legal maxim then is very useful in applying it in many different places. Okay, so they're called legal sayings or aphorisms in which they can be applied, and it helps the legal scholar and student to be able to sort of have a few things in their mind which can be applied generally in a particular topic. It doesn't mean that they can be applied willy-nilly. Obviously, those individuals who are in a position who give rulings, they will know the methodology of its application. But I have gathered a number here. I'm just going to quickly check how many I have gathered here. And there's about 60 odd here that I've put together at the end of chapter 4 in the text, which will look at that. And I'll just sort of mention one or two as I glance across them. When there is conflicting evidences, whether a thing is permissible or impermissible, it should be considered impermissible. So there you've got a legal maxim. So whenever two matters come up in any chapter, in any topic, in any kitab, and in one case it's saying it's permissible, another case is saying impermissible, what is given priority? The impermissible is given priority. When the asl is null and void, then the far is null and void. So if something has been qiyased upon, I apologize for making up my own words. If something has been qiyased upon, then and the asl becomes defunct, null and void, then as a result also that which was drawn from it, extracted from it, or derived from it will also go. Meaning that, let's just say we had a matter here, and which had come from some source text, and this new matter arrived, and we saw similarities between the two. So what we did was we transferred its ruling onto this new matter. But it so happens this now becomes null and void. Well, if this becomes null and void, then anywhere this ruling has been transferred will also become null and void. That's what's being referred to. Matters are according to their objectives. So that's another one which is used quite a lot. Haja is equivalent to darura, general or specific. Hudud is averted when there is doubt. So any corporeal punishments which exist, those which obviously are legislated by revelation directly, then in those cases where there is any doubt, then the corporeal punishments, I always have difficulty pronouncing long words, they will be removed because of the doubt which exists, where it's possible that the person wasn't involved in that particular act. Harm must be removed, and a greater harm is removed by a lesser harm, so kind of like a lesser of the two evils type of philosophy. Necessity permits the usage of the impermissible, and a number of others. Let me just see if I can quote you one or two more before we round this part off. There is no obedience of the Creator in the disobedience of the Creator. Do not cause harm, nor cause harm to others. Hardship brings about ease. General statements are qualified by the context. Averting harm is superior to gaining benefit. Certainty is not removed by doubt. Harm is not to be removed by harm itself. And one last one. A person who does an act even if he does not act intentionally, is responsible. So I've gathered from a number of texts, about half a dozen or so texts, I've gathered about 60 or so legal maxims which show a different area of the madhab in its application. And the purpose of all of this is to show that the madhab itself is robust enough, it's multifaceted enough, it contains many different areas within it to which it can actually deal with minority status, because that's what we're really discussing today. Even though it has within it the capabilities to deal with all matters, new matters, our main focus has been for this series is its possibility or its potential of being able to deal with a Muslim minority status and giving Muslims an identity and giving Muslims a way of living, even though they live in an environment which is not a Muslim majority situation. So that really brings me to the end of today's part, was just to kind of go over, and I did say both at the beginning of this part and this episode rather, and part one of this episode, that it is very heavy. The topic is very complicated. I hope that I've been somewhat successful in giving you a reasonable understanding, a very general understanding of how it works. But one thing that I hope I have done is facilitated an appreciation in you for the depth and understanding of a madhab. It's not something that just can be written off. It's not something that can just easily be cast aside. It is a complicated, detailed, changing, progressive in sense of progressive in terms of its application, not progressive in terms of its principles. And this is the thing which people find difficult to understand, is that when we speak of progressive and when we speak of being able to apply it in different, it's the inherent within the madhab. It's inherent with it. It wouldn't have survived for centuries, since the time of Imam Abu Hanifa in particular, when we're talking about the Hanafi school, up until now. It wouldn't have survived for around 1300 years. It would have been impossible for it to survive over a period of such a long time, in such diverse cultures, in different geographical regions on the planet, in all sorts of legal circumstances, until it was a state law or just practiced by people. It's literally been through anything and everything for 1300 years, and yet it still stands firm. It's not found to be wanting. It's not found to be unapplicable. It's not found to be stuck in some kind of time frame or some sort of backward understanding. It's there. Yes, when people don't get the answers they want to hear, then yes, of course people are going to say, well, this religion is like this and this is like that, because it's not telling you what you want to hear. And then that takes us back to the first few couple of parts, where we were looking at the hermeneutical model, where we were looking at the interpretive model, and we were saying, yes, you can't take liberalism and apply it and say, well, we're going to have to take a liberalistic attitude, we're going to use a liberal tradition to now interpret Islam. You can't do that. Reason being you can't do that because Islam, or traditional Islam, is itself a tradition. And liberalism is a tradition. So each has its own methodologies, each has its own practice. So basically it's a choice in how you live your life. That's what it is. We either adopt a path of choosing to live our life according to Islam, or we adopt a path in which we choose to live according to liberal values. We are both given those choices. And living in the in the century we live in, living in the society we live in, surely we have that choice to be able to practice a faith when it has no effect on anybody else and it's not breaking any laws, that individuals have that choice to be able to practice that faith. So that brings me to the end of the theoretical side. That brings me to the end of the sort of tradition. But now what we need to do is explore this tradition, the usul, and the its application. But now what we're going to look at is the status of land. Okay, meaning the status of land is, I did mention that in certain cases what we find is the Sharia is non-existent, depending on which particular environment we find ourselves in. In another circumstance we find that the Sharia is absolutely applicable, and we see things and everything else in between as a spectrum. So what we're going to explore now is how does that the impact of Islam, or the impact of the Sharia upon the lands, the areas, the countries, the political, as I refer to them in my text, the political legal jurisdictions, the diyar. And we're going to explore that in great detail. So I hope you can join for the next episode, which is looking at traditional usul and the political legal jurisdictions, in which that's exactly what we explore, which we will then hopefully lead on to giving a ruling for Britain. And once we've done that, we will then see how Islam, traditional Islam, continues to solve problems in Britain in various areas. I hope you can join me again. وآخر دعوانا أن الحمد لله رب العالمين. السلام عليكم ورحمة الله وبركاته.
الفسيح سبيل الدموع سبيل مريح تنهدى يا صاحي كي تستريح وبث الدعاء الخفي الصريح